Hello and welcome to part 5 of the NDA podcast series on business transfers. In our earlier parts, we have dealt with the key essentials of a business transfer, a comparative analysis between a business transfer and a share transfer, and the key tax considerations and employment related considerations that we have seen basis our experience in structuring and handling business transfers. In this part, which is the final part of the series, we will be dealing with antitrust clearance issues and some other considerations that we have seen are relevant while the parties negotiate a business transfer. Moving to antitrust clearance, if a business transfer qualifies as a combination as defined under the Competition Act, then such combination would require the consent of the Competition Commission of India and would be regulated by the Competition Act. With this, over to you, Khyati, in terms of explaining what are the other considerations that we look at when we analyze whether a business transfer would be a notifiable transaction. Are there any thresholds that we look at to ascertain if we can seek an exemption from such notifications?
Thank you, Harshita. First, let's get into what is a combination. So, combination as set out in the Competition Act means any acquisition of control, shares or voting rights or assets of a person, amongst other things. So, if you note, any acquisition of assets also is something that would be considered combination, and if it exceeds the thresholds that have been prescribed by the Competition Commission, would need to be notified to the Competition Commission of India before consummation of any step or entirely the transaction itself. Now, the financial thresholds have been prescribed under the Competition Act, which are linked to assets and turnover of the parties involved, as well as the groups pertaining to such parties. Now, it's interesting to note that, in April 2023, a Competition Amendment Act has been introduced, which has brought in significant changes to the merger control regime that may be applicable to different combination transactions. One important amendment that has been brought in is a new threshold, that is a deal value threshold that has been introduced. What this deal value threshold states is that if there is any combination transaction, the deal value of which exceeds INR 2000 crore, and such entity that is being acquired has substantial presence or operations in India, it will also need to be intimated to the Competition Commission of India. This new deal value threshold will not be eligible for any exemptions as are set out. Another important update in this regard is that the draft regulations in respect of the manner in which you have to calculate the deal value threshold and nuances around it have been introduced for public comments and are based on the public comments that it receives will finally be rolled out. So it will be interesting to note how this deal value threshold will be computed. Another exemption or threshold that has been provided is a small company exemption that the Competition Commission of India had ruled out in March 2017. What this exemption states is that if there is an acquisition of any value of assets which does not exceed, wherein the value of assets does not exceed INR 350 crore, or the turnover of such acquired business is not more than 1000 crore, in that case, even if the Section 5 thresholds are exceeded, the parties can seek this exemption and don't need to notify such transaction or such combination to the Competition Commission of India. Lastly, from a competition or an antitrust perspective, it's very important to note that if there is a multi-step transaction that the parties are looking to undertake, wherein, there is a business transfer involved as a step, which aims at achieving a, ultimate objective that the parties have agreed upon, then even before any step is consummated, such transaction needs to be intimated and notified to the Competition Commission of India. Such multi-step transactions with the intent of achieving the common objective are called as interconnected transactions. So even if any transaction is exempt but forms part of an interconnected transaction as CCI looks at it, All such transactions and steps will need to be intimated to the Competition Commission of India.
Thank you, Khyati. Are there any other considerations beside antitrust that we look at, while we are drafting the documentation or while we are advising the client on a business transfer?
Sure. So, other considerations would typically depend on the nature of assets involved in this business transfer. Before we get into the nuances in respect of each, there could be a range of 5 to 6 key assets, one being your financing or loans that have been availed in respect of that business undertaking. Second would be different contracts, that would be supplier, customer contracts, your leave license agreements. Third would be your licenses and permits. Fourth would be immovable property owned by such seller entity in respect of the business undertaking. And the last one would be the intellectual property in respect of this business undertaking. Let's get into the first aspect, which is the contracts. Typically in respect of a transferred business, the contracts that you would need to peruse would be your customer contracts, your supplier contracts, and the leave license agreements. Now, the manner in which these contracts would be transferred from the seller or buyer would depend on the terms of the contracts itself. So to say, if your contracts have an assignability provision itself, then it's a mere assignment that the parties can enter into to transfer such contracts from the seller to the acquirer. However, if there is no specific assignment related clause within those agreements, then the parties may need to enter into a fresh agreement, which means that the arrangement or the contract between the seller and such third party would need to be terminated and a fresh one would need to be entered into with the acquirer. In such scenarios especially, it's very crucial for a relation to be developed between the acquirer and such third party before finalizing the terms of the business transfer and also procuring a no objection certificate as a condition precedent, so as to ensure that the business is continued as is when transferred from the seller to the buyer. It's also not very uncommon that, in certain businesses, instead of agreements, there are purchase orders or supplier orders. In this case, also, it becomes very important that the buyer is introduced and ends up establishing good relations with such third parties before the business transfer is actually consummated, so as to ensure that such third parties continue their relations with the acquirer after the business transfer is completed. The last aspect in terms of contracts would be a subcontracting arrangement. Now, a lot of times parties would wish to not disturb the continuity of service and would intend that the contracts continue as is with such third parties. In such instances, typically the buyer becomes a subcontractor of the seller and undertakes all the aspects of the contract on behalf of the seller, and in lieu thereof, the seller in trust holds any receivables or undertakes any financial aspects in terms thereof in trust for the buyer, and eventually near the termination of such contract, then the buyer enters into a fresh contract with such third party. So this was the first aspect, which was on contracts. The second aspect is in terms of the licenses and permits. As we dealt with in part 2, essentially only if there are any registrations or permits which are solely in respect of the business undertaking that moves from the seller to the buyer, any consent requirements thereof is something that you may need to evaluate when it comes to actually undertaking and consummating the business transfer. All entity level registrations and permits, for example, your permanent account number in respect of the seller, continues to be with the seller and is not relevant for a business transfer. So as part of the diligence especially, it's important to make a list of any transferable or assignable licenses and permits which can move along with the business undertaking. The third aspect is your financing and indebtedness that the seller has availed in respect of the business undertaking. The first step in terms of financing is for the parties to agree whether the loans will also be transferred as part of the business undertaking or not. Irrespective of whether they would form part of the business undertaking that is being transferred, one important aspect would be to check for any requirements of consent from such lenders to as per the terms of the relevant financing that is availed. The second important aspect would be to understand any security that has been created in favor of these lenders. That is, if any assets that are being transferred as part of the business undertaking have any encumbrance in favor of these lenders, then it's needless to say that consent from the lenders and release of such security based on what is commercially agreed with these lenders would be the most critical step before such assets can be transferred. Moving to the next aspect on the assets would be immovable property. Typically, considering the value in respect of immovable property, a title diligence plays utmost importance as a condition precedent to a business transfer. A title diligence is conducted in respect of the real estate that is being transferred by way of verification of the local revenue records, with typically a look back period of say around 30 years. And only in case of a clear title that is having no sort of encumbrances in respect thereof, can a fresh deed of conveyance be executed between the buyer and the seller for the transfer of the real estate from the seller to the buyer. Like we have dealt with in our previous sessions, solely for the purpose of stamp duty and registration in respect of this real estate that is being transferred, a value can be assigned to this real estate so as to make the relevant registrations and filings with the local registrar. The last aspect in terms of considerations would be the intellectual property. Now, while there is no fixed or typical process that we have seen in transactions, what is important is to identify how critical is any intellectual property such as brand name, trade name in respect of the business undertaking that is being transferred from the seller to the buyer, and accordingly then decide the manner in which it should be transferred. That is a mere license or an assignment thereof. So these would largely be the other considerations while structuring and negotiating terms in respect of a slump sale.
Thank you, Khyati. And with this, we come to the end of our NDA podcast series on business transfers. Hope you all enjoyed this.